Good morning. I would like to call the San Mateo County Planning Commission meeting of May 24, 2023 to order. Please rise and join me for Pledge of Allegiance. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Mercedes, could we have the roll call, please?
Commissioner Ketchum,
Here.
Commissioner Serrano Kwan, Commissioner Chair Gupta,
Here.
Commissioner Ramirez,
Here.
Commissioner Hanson.
Here.
Thank you.
Next, we have oral communications. Is that? At this time, members of the public could speak on any item that's not on today's agenda. Mercedes, could you please explain the process?
For those attending the meeting on the Zoom video conference, we will use the raise hand feature in order to organize any public comments. During the general public comment period, and for each item on the regular agenda, I will ask those members of the public who wish to comment to click the raise hand feature to raise your hand to speak on that agenda item. For those joining by phone, please press *6 to mute or unmute, *9 to raise and lower your hand. When you hear your name called, I will prompt you to unmute your microphone and you may begin speaking.
Do we have any speakers?
There are no raised hands on Zoom.
How about any speaker cards?
There are no speaker cards.
Okay, seeing no speakers at this time, I'll close the public hearings. So we move on to our consent agenda. So at this time, we have consideration of minutes of the meetings from April 12 and April 26. Do I have a motion? So move.
Second.
A roll call, please.
Commissioner Ketchum,
Aye.
Commissioner Ramirez,
Aye.
Commissioner Hanson,
Aye.
Chair Gupta.
Aye.
Motion passes.
Next, we have the regular agenda item 2. I see that that has been postponed at this time. So we'll move on to item 3. Mercedes, could you please read the item for the record?
Item number 3, the owner, the applicant is Alexander Baggerman, file number PLN 2020-00467. The location is Chesham Avenue.
Go ahead, Erica. Okay.
Good morning, staff,
Testing, okay. My name is Erica Adams. I am a planner with the Planning and Building Department. Here to present item number 3, PLN 2020-00467. Okay. The project is construction of a new 3-story, 5,742 square foot, single family residence with a 501 square foot attached garage with a driveway, removal of 24 significant trees and 1,830 cubic yards of earthwork. The site is a legal 9-acre 9.73 acre parcel in the unincorporated area of Devonshire and San Mateo. It has dual frontage. It has frontage along Devonshire at the top there. And then the long pole gives it access from Chesham. This is an aerial of the site. The project requires 2 permits, a design review permit and a grading permit. This is the overall site plan with the easement crossing the adjacent parcel. This is an elevation of proposed residence, the colors and materials for the proposed residence. This will give you a little bit of orientation about the site. These are provided by the applicant. It's hard to access the site, so these are from his site, and then these photos were from the pole along off of Chesham. This is an aerial with an overlay of the site, and then the photos to the right are the Roberts property. It kind of shows like where they will be cutting through and the development that they have there that will be cut off. Okay, going back to site plans. Hopefully you were able to really look at those in the staff report or online, because they are hard to read here because the parcel is so large. But the house and the road are outlined there. And the civil plans have more information about the grading work that's going to occur on the site. This gives you an idea of where the trees are that are going to be removed. The ones in the shaded green areas are ones to be protected. These are the elevations of the project, floor plans, and roof plan. And again, we're looking at 2 permits here. So a little bit of background. The project came in 2020. Project review was a little over a year. The first hearing was in July of 2022. At the hearing, the project was already scheduled for the public hearing when I became aware that some of the access development was not within the easement boundaries. I was advised that the hearing could proceed and continue at a later date for a final decision. The design review committee heard testimony and indicated that they supported the design, but the hearing was continued so that the applicant could revise the project and place all of the development within the recorded easement. At the time of the meeting, the Roberts, the grantees of the easement, were unhappy with the development associated with the easement, which they will elaborate on later for themselves. After the revisions to the development were made and all development was put within the boundaries of the easement, earlier this year, the project was ready for a second design review hearing at which the design review committee recommended approval of the proposed design. At the meeting, the Roberts stated that this plan was not preferable to the first plan as far as development in the easement. And the civil issue of the easement, or the civil issue of the easement was outside of the purview of the design review committee. And staff indicated that the Roberts should work with the Buggermans to try to find a satisfactory conclusion. In January, the staff worked with the applicant and the Roberts to set up a dialogue and a meeting. There are different statements about what occurred in the end. But earlier this year, the applicant stated that he wanted to move forward with the plans that had been recommended for approval by the board, by the Bayside Design Review Committee. And those are the plans that are before you today. Okay, so the committee reviewed the project in January and looked at the design standards. They determined that the tree removal is within the path of the development, which is reasoning that trees can be removed. That the residents had a good site design and that the colors and materials are consistent with the design standards. And therefore they recommended approval of the project. Any grading permit which exceeds 1,000 cubic yards requires review and approval by the planning commission. The grading plans and geotechnical report have been reviewed by the geotechnical staff and geotechnical consultants and drainage staff through the building section. And they also have been reviewed by the Department of Public Works. All agencies have indicated that the preliminary plans are satisfactory to move forward to building process. In addition, staff has determined that the proposed grading does meet the grading permit findings, forms with chapter 8, and that reviews were adequate. Again, here's the proposed development. Staff has determined that the project is categorically exempt under CEQA for the single family residence exemption. And for findings for design review, the design review committee has reviewed the project against the standards. It's further discussed in the staff report, and they have recommended approval of the project. And as I mentioned, the appropriate agencies have reviewed the grading plans and found that it is, and the staff has found that it is compliant with the grading standards. Just going to take questions at this point. I'm sure there are some.
Thank you, Erica. Commissioner Ketchum.
Hi, thank you. So, condition 38 that was added, should the access shown on the plans go through neighboring properties, the applicant shall provide documentation that ingress and egress easement match the as-built condition of the constructed access prior to building permit approval. My question is, what does that mean? Does it address the proposed retaining wall that blocks access to the neighbor's property?
That is a public works condition, and basically they're saying that if it changes, everything should be within the easement. Everything is within the easement currently, including the retaining wall, the proposed retaining wall.
So it doesn't address the issue of the current road access then being changed to being blocked off with the retaining. It doesn't address that.
Does the current design, including the wall, is all within the prescribed easement. And so that is that's been reviewed and found to be satisfactory to zoning standards and location of being within the easement is not satisfactory to the grantees, but.
Yeah,
as
if
far
I
as-
could jump in there,
Sure.
please. So it does not resolve the concern of the property owner about the retaining wall. That's still of concern to the property owner. However, I would say that the way that condition is structured, it does provide an opportunity for the two parties to work together to reach a resolution. I think the position of the planning and building department is, given the current easement, the applicant has a right to move forward. Although it's stated in the letter, there's a dispute as to whether or not their proposed use is consistent with the terms of the easement, which I think is a civil matter between the two parties. But I think at the end of the day, both parties are interested in resolving this, and that they can do so under condition 38, because before the building permit can be finalized, it needs to be documented that whatever driveway was constructed was done so within the boundaries of an easement. Right now, the plans show that the easement in one location, but that location of the easement could be changed by mutual agreement of both property owners, and an associated revision to the driveway to stay within the amended easement area could, I think, very easily be signed off by the staff as a minor modification to the project. So I view the easement matter as a matter that needs to be worked out between the two property owners, and I believe condition 38 provides them with the time to do that.
I guess the way you describe it, that's that there's an opportunity to resolve this, but it's not for sure. And I feel like we're asked to approve a grading permit, and this is about the grading. If we say it's okay to do this grading and block their access wherever it is, I don't see how we can do that. I don't feel comfortable doing that.
Appreciate your line of questioning, and I think we should get into those matters, but if I may suggest that we get through the public hearing and continue deliberations after we hear from all parties. Thank you.
Commissioner Hanson? No question.
No
Commissioner-
question either.
So I have some more logistics type of questions, just trying to understand if we could go to the vicinity map. Yeah, the one before that, which also yes, that's the one. So I'm trying to understand that there's a portion which is between the home of the neighbor, who's, I believe that part of their property is being, or they and the applicant are talking about building access road. So this area where there's nothing built there, is that?
It's a vacant parcel. It's recognized as a vacant parcel by
Okay,
the county, that there's no development there.
okay,
There is some development there. So they own that little parcel, to the left of the driveway, and then they own that larger rectangular parcel. And that's where the rectangular parcel is where the easement's gonna come off of that pole and cross through.
okay. So that is owned by
Both parcels are owned by Roberts.
Roberts. Okay, all right. And this access road that we are talking about comes through. We are talking about that
Yes,
crossing that road.
right, it crosses through the parcel that's shown without a house on it right there.
Okay, and right now the proposal that we have is That's the one that it comes through there and.
The easement itself, the recorded easement, but in both situations, it came through.
came
But
through.
now that they've made some adjustments, there is a retaining wall that creates a shift in elevation that creates, before they kind of drive through, now they can't because there's, a drop.
Okay,
So that's the main, the line was always the same in a way, but there was some development like outside of it, and so
so
to
it has
put it
been,
in, yeah, to put the road in this time, I guess they put in a sharper, to put
okay.
it all in the easement, they put a sharper of the retaining wall in.
And at a future date, like there are no restrictions on this rectangular parcel that they cannot build anything
They
there.
could build,
They could build
yeah,
something.
they could build.
Okay,
I'm not in the weeds on their easement. I think their easement allows for them to take access off of that part as well, but they can speak to that.
okay, okay. So but there are no restrictions.
There's no restriction. Yeah.
Okay, on the parcel. Okay, all right. And currently there is some access on current applicants' parcels. There's some access from this Chesham Avenue. Chesham Avenue, there is an access road.
It doesn't go all the way. So when you're out there, I think it's hard to tell exactly what's going on the site, but the road, I think the road goes, it's too steep, and that's why they need kind of like to go laterally to get the fire truck and all. They can't just go straight on that pole.
Okay. Okay, understood. Okay. And there are 24 trees
Right.
Yeah.
Yes.
for removal. Okay. Okay, so that's all I have at this time. Any questions came up for other two commissioners? No. So if the applicant would like to speak at this time, please come to the podium and,
No, he's-
or are they
He's virtual,
remote?
yeah.
Okay, okay, so they have 15 minutes.
David Wilson. David Wilson, please unmute your microphone. David Wilson. Please unmute your microphone. David Wilson, you have been unmuted. Mr. Wilson, we cannot hear you.
Mhm.
Seems we cannot hear Mr. Wilson.
Wait,
Connecting to audio.
Can you hear us now?
Mr. Wilson, if you have two devices on, if you could shut the other one off, will prevent the echoing.
Okay, go ahead. Okay. Can you hear me? Can you hear me?
Yes, we
Can you
can.
hear me?
Yes, we can hear you, Mr. Wilson.
Okay.
You
All
will
right.
have 15 minutes to speak.
Let's go ahead and start. Everybody hearing everybody?
If you can just give us a moment while we
Hello?
speaker.
Hello?
Yes, Mr. Wilson, we can hear you and we are starting
Hello?
the timer. Now, I think you can't hear us. Is that-
Hello?
Oh,
I don't think anybody's hearing me.
we can hear you.
Let's just. Hello, is anybody hearing me?
Mr. Wilson, we can hear you in chambers.
Oh, okay. Okay, great. I was just making sure you could hear me.
Yes, we can.
I'm the owner of one of the 40-acre neighboring lots. Our property is multi-generational family-owned parcel. I've lived here for the full span of my lifetime of 50+ years. Our lot is on Highway 84, adjacent to the top end of Sam McDonald Park and the backside redwood forest of the project property. Our property, our land, our animal population, and our water is directly affected by the decisions of the owners of the connecting proposed property above us. There are many freshwater springs in all the valleys of our property. The tons of human and animal waste will directly affect the water system between us. Redwoods and other tree removal will disrupt the land and the freshwater system we have to rely on here. Any tractors, large equipment, or tree removal process here will cause excess mud, landslides, and land dispersing of the loose.
Mr.
water
Wilson,
system.
can I ask you to pause for a second, please?
Yes.
Thank you. Our intent was to call on the applicant to speak first. I assume you are not the applicant. So we're going to ask you to hold your comments until we first hear from the applicant, okay? So
Okay.
if you wouldn't mind, please muting your microphone and we'll come back to you.
Okay.
That's it. Okay, Mr. Baggerman.
Yes, good morning.
Okay, please go ahead. You have 15 minutes to speak.
I don't have much to add to what Erica presented to you, but this is a long-term project of ours. Both my wife and I planning to build our retirement house there. We really appreciate the opportunity to preserve the bigger portion of almost 10 acres land for not developed, for lack of a better term. And looking forward to everybody's comments and an opportunity to respond to comments or request for more information from the commission and from public at large. And I want to yield the rest of the time for other people.
Thank you. Let me see if commissioners have any questions for you. Any questions? Okay, so we do not have any questions at this time for you.
Thank you.
So how many speakers do we have on the? Only one speaker? Okay. On Zoom,
On Zoom,
on Zoom.
On Zoom, thank
On Zoom, yes. Mr. Wilson, can you hear me? Mr. Wilson, please unmute.
Mercedes, I suggest that we take comments from the chambers, if that's
Can you
okay
hear
with the
me?
chair. Oh, here we go.
Can you hear me?
Yes, we can hear you.
Okay,
You will have 5 minutes, Mr. Wilson, to speak.
okay. I'll start over. Our property, our land, our animal population, and the water is directly affected by the decisions of the owners of the connecting proposal property above us. There are many freshwater springs in all the valleys in our property. The tons of human waste and animal waste will directly affect the water system between us. Redwood and other tree removal will disrupt the land and the freshwater system we have to rely on here. Tractors, large equipment, or tree removal process here will cause excess mud, landslides, land dispersing of the loose water-filled soil. Destroying or harming our property's water system for this project and unadoptable pets in any way is not acceptable. La Honda raised, I grew up personally knowing the long-term family who owned the property on the proposed site before its new owners. The prior owners believed in preserving the land in its purest form.
Mr. Wilson, I'm sorry to interrupt again. I believe you're speaking about the Peninsula Humane Society project that's next on the agenda.
I'm speaking about all the trees that you're going to remove, the land disbursement, and the road that you're bringing in.
This is
above our
the
property.
project we're speaking about now is in Devonshire Canyon. That's not the project that you're speaking, Devonshire, unincorporated Devonshire area. I think you're speaking about item number 4. So I apologize. We're going to ask you once again to hold your comments for that item, and we'll go back to comments on item number 3.
Okay, so there's no house being built up on the proposed property above?
Could you please identify the property that you're speaking of?
There is a 120 acre parcel above us, and there is a triangle shaped property right next to it. Is this the property where the house is being set?
I don't believe so. So the address of this project is on Chesham Avenue in Devonshire. The next project is located on Pescadero Creek Road in Lomamar.
I don't, your map here shows right above us, what I'm looking at here.
Okay, do you have the agenda in front of you?
Yes.
Okay, can you tell us what item you're speaking on?
Speaking on number 3.
Please continue.
Is the item 3 that he's speaking of.
Now you're there?
Please go ahead.
Okay, so this is being built right above us in the same spot. I also want to go on to say that there are many endangered and protected animals living here on our shared properties, including mountain lions. They just introduced bald eagles, California condors, the giant California salamanders here, many others. The farmlands to the west and the town of La Honda to the east push these animals into our uninhabited lands right here with us. The majority of the animals have taken refuge here in the park system and do not know the boundaries between our property. Even though the mountain lion's territory is 30+ miles, the lion's den is located directly on the corner of my property, the proposed property, and Sam McDonald Park. It's a huge den of mountain lions. This is where they live. This is where they sleep. This is where they eat. Bringing any type of human contact near the animal's den here is not going to turn out positive for either the humans or the animals. The den is huge. Nobody's taken this into consideration. Nobody has looked at or inspected where the mountain lions live. It is directly on the corner of where we're at and where this proposed property is supposed to be building. The human population is too dense in the surrounding areas, and there's nowhere else for them to go. I am against any humane disposal, trapping, or removing or harming the population of our property's wild predators or any animals. It is hard for me to imagine the owners ever thought their property would become an industrial compound of cell towers and buildings containing unwanted house pets. Has anybody talked to the actual park system and the rangers themselves? These animals have collars and they can be tracked, and they can show you exactly where these animals live, and where they hunt is exactly where the proposed building is going to be erected. This is not going to turn out good for anyone. So I have problems with trees being removed. If there's any redwood trees, any kind of clearing of redwood trees, my understanding is that you need permission from the adjacent owners. I do not give any permission for any type of tree removal anywhere. Any kind of tractors or anything like that are going to mess up the water system. Any kind of human population up there is going to be in directly in the midst of the den, the lion's den that is located right where you're building the property. And I want to know how is anybody looking out for these animals? Does anybody care? These are supposed to be protected animals, and it doesn't sound like we're protecting them. That's all I have.
Thank you.
I don't believe there's any more speakers online. We can move to the speakers in the chambers. I'd recommend beginning with the appellants, unless there's any representative of the applicant in the room. No? Okay, we'll go ahead.
Thank you. Go ahead, Mercedes.
We do have one speaker in chambers at this time.
Okay.
Jennifer Larson.
Testing? Oh, I turned it off? No, that was right. Okay, so I submitted a statement as well, but I'll read it before chambers as well. So my name is Jennifer Larson. I live at 351 Chesham. If you looked at the map, so I am below the Roberts. If you actually go to the property, you have to drive right in front of my house. I'm at the end of the turnaround. Then above me is the Roberts 2 parcels, and then the proposed project. So my name is Jennifer Larson. I own 351 Chesham Avenue with my husband, Russell Larson. I live at the end of the street, and I have several concerns about this project, but since we're here to discuss a grading permit, I'll focus those issues on the grading and the logistics of the project. At the narrowest of the street is 12 feet wide. On the south side of the street, there's a hill, driveways, and parked cars and retaining walls. Those parked cars are there all day long. On the north side of the street, there is a creek with no guardrails, and it drops right into the creek. And that edge of that street is already eroding from the water runoff that we had this winter and from the constant street traffic. Delivery trucks on overhead are oaks that are very low hanging. Any sort of delivery truck will hit them. Delivery trucks and the weekly garbage truck fully block all traffic on the street, hence the construction vehicles will as well. My limited research on the heavy construction equipment needed to do this proposed grading project will either not fit or barely fit down the road. What is the proposed plan to get the construction equipment up to the site? Where will it park, especially at the beginning? In addition, the grading permit is for 1,830 cubic yards of earth. The standard dump truck, again, based on my limited research, carries 10 to 14 cubic yards of earth. This means at a minimum, it will take 130 runs of dump truck down our street just to build the driveway. With the constant traffic down the street, how will they guarantee that we will have constant access to our property to come and go as we please, allow emergency vehicles to access our property when or if needed, or have visitors come to our home? If the street is blocked or damaged, we are either trapped in our homes or trapped out and without a way to get out, and this is unacceptable. There will be a long-term construction project that will destroy the neighborhood life that we enjoy for several years. The process and logistics of building this home cannot be separated from the design process and need to be included in consideration for approval. I would like the committee to take into account the building process and approve the project, not just the final home design. Also say as a side note, there are 6 small children that live on this street. Part of their enjoying the neighborhood is that they play on the street. They have a shared fort that is in the middle of the street that they all access on a daily basis. And we're talking about children aging 9 months till, well, they're 16-year-old, but I don't count them as the kids, up until about 6 years. And their safety is something, as the mom of one of those little ones, very concerned about. But we'll talk about the road. Any questions?
Thank you, Ms.
Thank you.
Larson.
Our next speaker is Kamas Steinmetz.
Good morning, Chair, members of the commission. My name is Camus Steinmetz. I'm a land use attorney and partner at Jorgensen, Siegel, McClure, and Flagel in Menlo Park. And we were recently engaged to represent Teresa and Ronald Roberts, the immediate neighbors to the proposed project. I submitted a letter to you late last night that I think Mr. Monowitz passed out this morning. And as explained in my letter, the proposed driveway and sole access to the project site traverses over my client's property and includes a retaining wall that effectively cuts my clients off from access to their property. The retaining wall increases the burden of the easement on my clients, of the easement that my clients granted the applicants. It also deprives my clients of any benefit to the easement that the applicants granted my clients in exchange. And it breaches the road maintenance agreement that calls for a single roadway shared by both parties to access their properties. And perhaps most important to the county, it would prevent my clients from accessing their property to continue their significant fire abatement and protection work on their property and any emergency vehicle access to the property. Accordingly, the proposed driveway poses a health and safety risk, and it is our opinion that the applicants do not have the legal right to construct it. We therefore ask you to reject it or continue the hearing to allow the applicant to return with a proposed driveway that they have the legal right to build and preserves access to my client's property. We expect that this would be accomplished with negotiation of an executed amendment to the easement to accommodate something similar to the original driveway that was proposed, which is in the best interest of both parties. Thank you for your consideration.
Thank you, Ms. Steinmetz.
Our next speaker is Ron Roberts.
Also, I don't think anybody commented, the retaining wall is 14 feet tall, which higher than the ceiling, which also makes me think of safety and how high. I don't even know how high you can build a retaining wall, but it certainly feels like it's not a safe thing to do. And we always have lots of kids, including Jen's, playing way up on the hill. Access if there was an accident with this wall for any, if the fire department had to get there or somebody was hurt, I think that's a real safety issue as well. One of the issues is when they started designing this 40+ feet of retaining wall onto our property well over a year ago, we should have been included in that conversation back then, instead of finding out the day before the meeting, printing up the plans and seeing that they had decided to do this without any of our permission, which is why we've had to get help from Camus and try to figure out what to do and what our rights are and how to move forward. This retaining wall completely blocks our access to where we have access today. It would take it away. So that's kind of where we're at, and that's why we're opposing this this part of the plan that apparently it's been recommended for approval. I think that's it.
Thank you, Mr. Roberts. Do we have any other speakers, Mercedes?
Chair Gupta, it does not appear we have any additional speakers in chambers, but the applicant had reserved some of their time for a rebuttal, and it looks like they'd like to speak now.
Okay. No more speakers?
We have no more speakers in chambers. We do have Alex Baggerman on Zoom.
Okay. Okay.
Yes. Hi, thank you for the opportunity to address some of the concerns that were raised during this conversation. We absolutely agree with everything that Kama's statement just stated. We absolutely, our intent is to proceed with well-organized solution that is agreeable to everybody. Unfortunately, Ms. Stamets was engaged very recently. The first communication that we've got from her was yesterday, and she doesn't have the full background of the project. Two previous attorneys who represented Roberts over the course of the last 10 months informed us that they cannot represent Roberts the moment we shared all the background information with them. We participated in a session arranged by planning department, where we fully agreed with Robert's desire to go back to the original design, only to get complete lack of communication from Roberts. None of our messages that I can share with Ms. Stamets when she has time to get the background information on the project. And moreover, the lawyer who was supposed to lead those negotiations on behalf of Roberts informed us that he is no longer represent them. We tried to do prescribe our easement negotiation session arranged through third party, and this information was shared with Roberts along with plans, and to which Roberts never replied. So we only went with the current design because we cannot get any response from Roberts on all our proposals, including our offer to pay for complete redesign of the driveway to reflect Robert's desire for the driveway layout. I shared with Roberts information, contact information for our civil engineer, who was never contacted by Roberts. Along with other things, we paid tens of thousands of dollars for engineering cost in anticipation of project redesign offered by Roberts, and again we're faced with lack of complete communication from Roberts. So at this point, I would like to ask Commission to approve our project, and if Roberts ever come back to us with reasonable proposal, because all previous times they expressed desire to do redesign and then disappear and refuse to reply to our messages and voicemails. So at this point, I would like to ask Commission to proceed with approval of our project if our project complies with all the county requirements and regulations. And I would be happy to answer any follow-up questions.
Thank you, Mr. Beggarman, for responding.
I think that concludes our speakers. Am I correct, Mercedes?
That's correct.
I'm sorry, at this time, the public hearing is closed.
Thank
Would
you,
you
Chair.
like to
Yes, I'd like
respond?
to ask our council to respond to some of the legal matters that have been raised today.
I'm going to talk very briefly about easements, so I hope I don't bore you. But I think there are some conceptual groundwork that if I lay it out now, it might help improve the deliberations and give you an idea about a path forward. I think people understand easements well enough in a practical way, but in a legal way, I think it's important to recognize that they have two components. One is they're lines on a map, and they're depicted in most cases, not in all cases, but in most cases, as having a particular alignment on a parcel. They're also a set of rights and responsibilities that flow both ways. The responsibility of the fee owner, the owner of the underlying property, is to allow certain uses in the easement area. And it's also a responsibility of the owner of the easement to perform those uses in a way that does not unduly burden the rights of the underlying property owner. So the rights and responsibilities flow both ways. It's not a one-way relationship. When the planning department encounters an application like this that proposes development in an easement area, generally the department's analysis is limited to the question of whether or not the development is proposed in the easement area, as I described it at the beginning. Is the development falling within these lines on the map? Because clearly, if they're outside the lines on the map, we would need to have an owner's concurrence that showed that the underlying property owner consented to the development occurring on property that was outside the scope of the easement. This case presents a somewhat more complicated issue because all the development is proposed to occur within the easement area. I believe it's undisputed that all the development proposed is within the easement area. However, there's a controversy over whether or not the proposed development is within the scope that was contemplated by the parties that entered into their easement agreement, which is a voluntary transaction where you sign a document that says what it is you're going to allow to occur and what you don't expect to allow to occur. Generally speaking, the planning department does not undertake to perform the role of interpreter or mediator on the question of whether or not the proposed development exceeds the scope, I'm going to say the scope of the easement, as opposed to exceeds the boundaries of the easement. We decide to perform the ministerial task of confirming that the development is proposed entirely within the boundaries on a map. And when there is a dispute about whether or not the underlying agreement between the parties authorizes or forbids or impliedly authorizes or impliedly forbids the things that are proposed in the application, our response is usually that that's a matter that can only be resolved in court, because any resolution that the planning department would come up with would not be conclusive. If we told the applicants that they could not proceed with their application because we ourselves were not convinced that the development was authorized by the easement agreement, it would not be conclusive on that issue. We perform the role of granting and approving permits that align with our regulations, not necessarily granting and approving land uses based on whether or not they comply with or violate agreements between private parties. So hopefully I'm presenting a very neutral perspective on the merits of the controversy, but I would say that the reason why you're seeing the situation that you're seeing is that generally the planning department has a responsibility to process applications to hearing by certain deadlines and present to you the issues that are teed up for the commission to decide, which are whether or not to grant or deny permits based on the regulations adopted by the Board of Supervisors. And ordinarily we tell applicants and opponents that have these types of disputes between them that relate to documents that they control, that are not regulatory documents that we created. They're documents that they created and either regret or hew to, that they work that out between themselves. And unfortunately, when that is the only approach, when that's the only practical outcome for the planning department to pursue in getting matters brought before you in a timely fashion, you don't get conclusions by issuing the permits, because then there's a controversy that lives on after you've granted or denied the permit. If you grant the permit, there could be ongoing controversies between the neighbors about whether or not they need to go to court to have a resolution of the easement. What I would say is this as a form of advice about your deliberations. It sounds to me, based upon the testimony presented today and some information from the planning file, that there was an alignment to the driveway that might be preferable, but that did not comply with the boundaries of the easement. And so as a result, the planning department said, we can't process the application because the boundaries are exceeded by the scope of the project. Those boundaries can be adjusted by voluntary agreement between the parties. But it sounds like a lot of time has passed without that actually happening. It is possible for the commission to perform its task of giving an up or down vote on an application presented to it, and to impose the conditions recommended by staff, or if there are other conditions that you're considering to propose that might be value added to the project going forward. But it may also be an opportunity for the neighbors to get the driveway alignment that it appears both of them prefer to the one that's proposed before you now. They have different reasons for why it failed the first time around, but it is definitely within your purview to look at the procedural posture of the project and to decide that you would rather see a proposal that better fit the alignment that was originally proposed, but that the parties had not been able to document in time for the design review process to be concluded. In other words, I'm as your counsel, I'm not recommending a particular path forward, but I am saying that if you wanted resolution, an up or down vote on the permits before you today probably isn't going to provide it. It's not going to provide resolution. And there might be an opportunity for there to be enough agreement between the parties for a future hearing on the same permits with some adjustments made to actually result in more permanent resolution of these issues.
Thank you, Tim. I just to kind of reiterate his last point, I think it appears that there might be an opportunity for resolution between the applicant and the Roberts, and should the Planning Commission want to provide more time to enable that to occur, certainly action to continue it would be appropriate. If you were to choose that path, I would suggest that we would continue it to a date certain so that there wouldn't be undue delays posed on the applicant's ability to move forward. Be happy to answer questions if you have any.
Thank you.
Before we get into, this is probably the core question. I would like some response to Jennifer's questions, which are about the street and the thing. You know, she had a letter and she did ask.
Oh, certainly, and certainly understand and appreciate those concerns. To me, it sounds like it's the project's going to demand a very careful construction operations and staging plan. And if the conditions of approval don't adequately address that currently, I would recommend we take another look at those conditions to see if they need to be supplemented in any way to make sure that the unique circumstances of the site and the safety concerns are appropriately addressed in the construction plans.
So do they, conditions of approval include, damages to the overhanging trees.
Well, it does require a tree protection plan indeed.
So that would, yeah,
Yes.
underneath that, okay.
Yes. And, I think a lot of the speakers concerned related to activities that might occur within the street itself, which would be regulated by the Department of Public Works encroachment permit process. And the Department of Public Works would set terms regarding how that operation could take place to make sure it didn't disrupt traffic or minimize this disruption to traffic and was done in a safe way. And we collaborate with them and the concerned residents to make sure that those concerns are addressed to the best of our ability.
So if I can repeat back, what I think I heard was that the conditions of approval have the things that she's looking for. They will be determined at the time of construction to ensure that these things do happen, but there's no specific plan in place today.
That's correct.
Okay, thank you.
Question that I have is something that Commissioner Ketchum brought up is if we approve today, if we go ahead and approve the project today without really having a clear understanding of what this access road is going to be looking like, and the grading may change after the two parties reach an agreement and document something. How would that play out? Does that then come back to Planning Commission in any way? Or is that taken care of by Planning Department?
I think that the driveway access and what it will look like as proposed is actually fairly well understood at the moment. What we don't know is whether or not as the project proceeds, there'll be requests to modify the alignment to reflect either discovery of geological conditions or something like that, or because the parties have reached some other agreement about the alignment of the driveway. I think Steve has already said that if there were adjustments made to the alignment following an approval today, that they could be treated as minor modifications and processed by staff as opposed to brought back to the commission for a new hearing. But again, that if it goes outside the boundaries of the easement, the department can't approve that as a minor modification in the absence of a modification to the underlying easement document, because those lines on the map are something that the county does not have the power to move. We don't have any discretionary ability to say this driveway is much better if you put it 3 feet to the left, if that puts that on somebody else's property.
Could you explain how do I see the easement boundaries on, like, where are those specified?
I have not myself looked at the recorded maps, but generally speaking, and this is speaking just very generally, I don't know for a fact that it's the case here, when two neighbors reach an agreement about an easement, they prepare a document, generally a fairly short document, that describes what it is that's proposed by way of use. And then it says that the boundaries of the easement shall be as depicted in Exhibit A. And then Exhibit A is often a legal description, set of words that describe how exactly to map out the property. And then usually there's also a map. And then often, though not always, often that map is recorded with the county recorder's office so that subsequent purchasers are put on notice that when they acquire the property, they either obtain the burden of complying or the benefit of the access. So I know from prior conversations that the actual boundaries of the easement were known to the planning department in order to process the application.
because I've heard that term, but I was not sure if not that it was not there, but that I noticed it in anywhere in the report that this is the easement and this is where how it was not met. The easement was not met.
Yeah, again, speaking very generally, sometimes easements are they've been historic uses, and then the parties are just trying to confirm that they will continue to have the right to access their property over a particular path or whatever. Oftentimes when you're talking about raw land and you're imposing a new easement that hasn't previously existed, best practices are to have a survey of the property done and actually install monuments on the property that describe where various points are. There's a whole profession, as Mr. Hansen knows, there's a whole profession dedicated to the task of truthing the things on the document in the real world and vice versa. And I don't know the level of detail that we've had, whether there's a survey on the property. I don't recall from the prior conversations whether that's the case here, but at least for us to process a planning application, the person who proposes the project comes to us with evidence that they own the property and evidence that they have the right to build on the parts of the property they don't own, in what the lawyers call fee simple. They're not the underlying landowner, they have an easement right. And we, take that in as part of the application process to make sure that the application is for construction on property that the applicant has the ability to build on.
Thank you. Thank you for explaining it, Mr. Fox. So would you like to?
So Mr. Fox, I think normally when I like to hear like your legal explanation, and normally I get like, a more better way to make a decision on this. But I think right now, I don't think you're making it any easier based on what I've heard you saying, because the way I look at it is like we are caught in between what is a civil matter that has not been resolved. In either way that we decide to go, whether we approve or disapprove, I think it will have to be resolved in the courts. So
and not necessarily. I mean, I think that there's a good potential there. But go ahead, you finish your remarks.
So I'm just because I think Mrs. Ketchum alluded to this earlier, that I'm not sure that we that we have the proper jurisdiction to make a decision on this, because we can go based on the regulations of the county, but we're looking because I don't see, as you say, what's the actual, we don't have the actual verbiage of what this particular easement says, because like you say, each one, each easement gets recorded and there's the way that it's going to be used. And I haven't seen at least how this one is recorded. And
I don't think there's really any controversy about what the document says. It's really a controversy about whether or not the project as built would produce a burden on the underlying property greater than the parties contemplated when they entered into the agreement. And I would leave it to Ms. Steinmetz and her counterpart on behalf of the applicants to describe better what the controversy is. But essentially, the easement document doesn't specify in great detail exactly what the driveway is going to look like. And what's currently proposed, which has a retaining wall that would effectively cut off access across the driveway to the underlying ownership, Ms. Steinmetz contends is an unreasonable burden on her client's property. And that might be true. It's just that we ourselves are not in a position to adjudicate it. So it's not that we don't know, it's that it's not our, and it's not that it's not our issue. It's just not our decision whether or not it unduly burdens. It's really between the parties. They can decide how much burden to bear, and they can decide how much burden is worth having an ongoing fight about. So in other words, and I think what Steve was alluding to is the most productive outcome, if it can be achieved, is for the Roberts and the applicant to come to an agreement about the driveway. They came to an agreement about the driveway some number of years ago, apparently, but it's not providing the level of clarity that's necessary for them not to be in controversy now. And so I think Steve's suggestion is that, at least on the facts that we know now, there's a potential that a different driveway alignment would be preferred by both parties. They're just forced to proceed with an application that follows the current alignment because of the state of the legal documents as they exist right now.
Yeah, and just to add to that and to return to what is within your jurisdiction, as part of the grading permit, of course, we want to make sure that we minimize impacts on the environment, on adjacent property owners. And I think if there's an opportunity to do so by providing time for additional negotiations that would lead to a driveway that could have lesser of an impact on the environment, that would be consistent with the purview and objective of your review. I just think we can't extend that to the point where we deny this property owner the right to move forward at some point. And that's why I suggested if you were to continue, you would do it to a time certain. That way, if they're unable to reach an agreement on what we all think might be a better driveway design, then we can come back to whether or not the applicant has the right to build as proposed.
Okay, thank you.
Commissioner Ketchum.
So I would like to propose that we continue this item to a date certain, and that the applicants come back with a plan showing the easement, probably revised, and in other words, or some way to not block access through their grading to the neighboring parcel. Have I said that right?
Well, I think the commission lacks the authority to direct the applicant to do anything particular. I think the basis of the continuance sounds like it is to provide the applicant with the opportunity to work with the Roberts to attempt to reach resolution, preferably on the driveway that doesn't block the Roberts' access to their property. And with regard to the date certain, I would propose that we bring it back within 2 months.
Okay.
And what about the issue with the conditions of approval for construction act, access, staging, tree protection law? I just recall all the details that were involved with Ascension Heights. Did that get applied during the building permit stage, or was that something that the planning commission?
Well, in that case, we had a unique condition that required the planning commission to sign off on certain details, but that will take place. And if this item is continued, I will work with the planner to make sure that those conditions regarding construction operations are as strong as they need to be when the item's brought back to you.
Okay, I found as I went through the staff report, this before I saw the correspondence, but although there was correspondence in the back from the Roberts, and that all along, as I was trying to figure this out, I wished I had a copy of this easement, because it wasn't clear in the staff report anything about whether the road, the existing road is pre-existing, who built it, what the act, it was very confusing. And then when like I say, I saw the letters in the back from the Roberts about this shared use, and that the Roberts as well had a access road that was pre-existing, that they used it, and that was all to be shared. And I only got that from the correspondence. So I suppose this is my desire to have this when it comes before the commission, to have it all clear about the right of access. And this just gets down to the grading. If you're going to move the dirt around, you're going to put this thing where you're going to have to block access. That just doesn't, it seems, it doesn't seem right. So anyway, I guess we're left with, would just like the continuance to 2 months, did you say?
Yes.
And without any qualifications or whatever it was you said?
Well, I just expressed the commitment of staff to make sure that the conditions of approval adequately address construction operations.
Oh, well, no, I meant that the continuance is to
Oh, it's the-
resolve this issue about that what we approve needs to be fit within the access easement, whether that's a revised access easement or whatever it is they decide to do. Because you said the county has to have that.
Yes,
meet that
I think the basis of the continuance has been made clear, and I think what's important is the record reflects that it's been continued for 2 months. That's the most important.
So that's your motion, right? And
Yes.
that's, okay, then I'll second that.
And only one other comment, since there's anything else on the table that we should consider, and one of the things we're supposed to consider is the design review. And I just want to let the applicant know I'm happy with the design. And to me, that's not on anything they need to adjust.
Yeah, same here.
Yeah.
Okay.
Roll call. Mercedes.
Can you please repeat the motion for the record?
The motion is to continue for 2 months.
Thank you.
We can do a roll call now. Yeah, thanks.
Commissioner Hanson,
Aye.
Commissioner Ketchum,
Aye.
Commissioner Ramirez,
Aye.
Chair Gupta,
Aye.
motion passes.
Chair Gupta, if I may request that we take a 10-minute break.
Absolutely.
Thank you.
We'll take a 10-minute break and be back at what is
10:25.
10:25.
Thank you.
Yes, yes. And I hope we should take them towards it. They are neighbors and they want.
So continuing with regards to compliance with the zoning regulations, the property is zoned resource management, RM. And so staff has evaluated the project relative to compliance with the RM development standards, as well as the RM development review criteria, and has concluded that the project complies with applicable standards and criteria. Additionally, parking, with regards to parking, the project proposes 10 parking spaces and plus a 2-car garage for the caretaker's residence. And so staff believes that this is in compliance and will satisfy the parking needs for the project. And staff has concluded that the project would not have any significant adverse impact to the environment or be detrimental to public welfare or injurious to property or improvements in the neighborhood. The project has been reviewed by a number of agencies, including, as I mentioned, Army Corps of Engineers, as well as California Fish and Wildlife Services, along with county agencies, including Environmental Health Services and our Civil Drainage Review section and Geotechnical section, and all agencies have provided conditional approval. With regards to the kennels and catteries ordinance, the staff has evaluated the project and determined that it complies with the general requirements of the kennels and catteries ordinance related to maintenance and care and well-being for the animals, as well as adequate building and structures and facilities and outdoor space. And with regards to specific requirements, both for kennels and catteries, from the kennels and catteries ordinance, staff has evaluated the project and determined that it complies with these specific requirements as well, related to being adequately distanced from any nearby residential properties, and would be designed and is designed and would be constructed to meet current code standards, and to minimize any environmental impacts. So a grading permit is required with the project, and so staff has evaluated the project relative to our grading ordinance and determined that the project does comply with the findings that are necessary in order to issue a grading permit, which is that the granting of the permit would not have a significant adverse effect on the environment, that the project as proposed and conditioned would comply with the grading ordinance, and that the project is consistent with the general plan. Staff completed an initial study and mitigated negative declaration for the project and circulated it for a 20-day public review period as required and in compliance with the California Environmental Quality Act guidelines, and no comments were received. And mitigation measures from that document have been included as conditions of approval in attachment A of the staff report. And so with that, staff's recommendation to the Planning Commission is to adopt the mitigated negative declaration and approve the resource management permit, use permit, kennel and cattery permit, and grading permit, county file number PLN 2021-00316, by making the required findings and adopting the conditions of approval in attachment A of the staff report. So that concludes staff's presentation, and I'm available for questions. Thank you.
Thank you for your presentation, Summer. Commissioner Hanson.
Got a small question. I presume the existing cottage has electricity, but we're putting in a new power line that is not on the same feed?
I am not sure. New power lines are proposed to support the facility demands. I'm not sure related to that existing cottage, if it's in use and what the utilities to it currently are. It is proposed to be demolished. I may defer to that applicant to see if they have insight on the existing utilities to that,
I mean,
that structure, if there are any right now.
being in a scenic corridor, adding poles where none are needed, if you could use the existing line, I just wondered why.
It's not unusual in the rural areas for the existing power lines to not have adequate supply to meet modern needs.
Okay,
So I wouldn't be surprised if the reason is that the line that currently exists is not capable of delivering the electricity they need, but hopefully the applicant can respond when it's their turn to speak.
because,
I get your point. Absolutely.
just doing my duty is protecting the scenic corridor, even though there
Absolutely.
be limited things, but it is a long way to put a power feed, and it's the one question that jumped in my mind.
Yes. And I will note that the front portion of the project site, primarily a portion of the access to the project site is within the a county scenic corridor. However, the remainder of the access road up to the project site and the project site eastward itself is not in a county scenic corridor itself.
Okay, that's my only question.
Commissioner Ketchum.
Well, I have a question that is probably for the applicant. Are they going to speak?
The applicant did have a short,
Okay.
yes, speech.
Commissioner Ramirez.
No questions.
I had a question on the noise study. Maybe applicant could address that better. So I'll wait for that. Thank you. Thank you, Summer. Would applicant like to speak?
Sure.
We have Greg Hagee in chambers. Mr. Hagee, please start speaking when you see the timer. You will have 15 minutes. You will have 15 minutes.
Microphone's good. Commissioners, good morning. Staff, good morning. Thank you for having us. That's a tremendous amount of information. Again, thank you again for the presentation. We've had the pleasure to work with the Peninsula Humane Society, SPCA, for quite some years now. They've been here supporting San Mateo for just over 70 years. They see about 5,500 animals come to them each year to flow, through their facility. The majority of those animals are adopted. There are some animals that just can't be adopted. And this particular facility is to take care of those animals that are not or never will be ready for adoption into a family. So that's the purpose of this facility. We've done a tremendous amount of due diligence on this site. The site is large, just over 200 acres. We're purposefully touching a very modest piece of that. It is, we're about 5% of the site is what we're touching. So we've tried to have a modest or a light touch on the site itself. The proposed buildings, the larger of the buildings, you saw the intake building with the vet offices, support buildings. Those are being constructed on or about where the existing barn and the existing residence occur. It's up on by North Tree Line. The majority of the pens for the dogs and cats are south of that, down a hillside. Again, a lot of due diligence there. A lot was the road, the fire department getting access to the site, and commissioners, you've touched on the power, the well, those have been presented here. So a comprehensive look at the site. The architecture of the buildings, again, is going to be modest in keeping with the hillside. We can't see any, again, neighbors from where our development is taking place. So those are the general aspects of the plan. Again, in terms of the use, I'm just looking at my notes here. The one caretaker's residence, he's going to be on site to alert. This will be 24 hours to alert any safety issues that come up. The caretaker will be there, and then volunteers will come in on a daily basis to care for the animals. That's the overview of the project. The project manager, Jerry Garcia, is here. He can help answer specific questions. Jerry Griffin, with regard to the power. So Jerry, I'm going to invite you to come up. I'll give you a little shout out as Garcia. Come on. My favorite. Please.
Good morning, all. First off, to keep it simple, my name is Jerry Griffin. I'm the project manager. I've been involved with the Peninsula Humane Society for about 12 years in a variety of roles, and all related to construction and construction development. In regards to your question, there is no power today or water on the site. That cottage is non-conforming, not permitted, basically a shack. So the best thing that could happen to it is what we're doing to it. Unfortunately, we looked at a lot of different options for power, and the most efficient and economical and possible was the current drawings and the poles that you noted. I thought somebody else had a question in regards to the site.
Did you have a question?
Yes, I don't know if you can answer this either, but I gotta ask, how do they get the cats back in their cottages?
I'm going to leave that to the people that do that for a living. They are very adept at it, but good question. I've got a lot of different answers to that, but I'm going to let them deal with them. Anything in regards to the site, the development of the site, that's kind of my specialty. We've gone out and drilled a well. The existing well that's there is dry and needs to be abandoned, so we'll effectively abandon that through county health. So we'll get the cat question answered.
Did you have any questions? Did you? No.
Good morning. My name is Katie Deneen, and I'm with Peninsula Humane Society. I oversee shelter operations along with my colleague Dana, who's here. Cats can be tricky. We know that from working with them on a professional basis, but the way that we would encourage them to go inside in the cottages is that's where we will feed them. So we'll have cozy little places for them to be in there to sleep and hang out, and that's where they'll eat. So that is the lure to get them to go inside.
But does each cat know which cottage it lives in?
They can organize that amongst themselves.
Oh, so you don't
we'll
care.
let the cats,
Oh,
with
I
that
see.
large open area, the cats can be outside during the day. We're feeding them inside, and so they can choose their own territory and will form their own little groups to decide who sort of sets up permanent residence in which of the cottages.
Very interesting. Thank you.
Commissioner Gupta, did you have a question?
Yes. I had a question about the noise. If the dogs start barking at night, how is that controlled? And how close are the neighbors there who may get bothered by it? I've seen some of the noise study reports that are in there. Have neighbors complained that that would be an issue?
Understood. In regards to the dogs at night, they're inside their little houses, so that would be not likely. That's one of the reasons of bringing them inside.
They won't be like they won't create too much noise.
Not
once they are
inside at night,
inside.
no. Going back to the cats a little bit, the dogs would be a little bit similar. The compatibility issues will be addressed right away to make sure the dogs, if there's a couple dogs in their respective little homes, then they'll make sure they're compatible together. But they'll all be back inside at night. And
if I may also, based on the noise study that was conducted, which again did focus primarily on dog barks, both daytime and nighttime noise source. The nearest closest residence is approximately 2,700 feet away. So it's a pretty far distance. And as Jerry mentioned, during the nighttime hours, the dogs would be inside in their cottages. And I believe part of the duty of the resident caretaker would be also to be able to be on site and be able to address any dog barking that occurs in the nighttime hours in a fairly expeditious manner, because they're right in the kind of compound area.
And one of the correspondents had mentioned that there could be wild animals or like mountain lion population around the park, like outside the park, but you cannot prevent them. So is there some kind of measures that would be taken so that they don't come in daytime, nighttime? Like even in our residential neighborhoods, we face those kind of issues that later in the evening there could be mountain lion walking around. So people who are walking their dogs have to be careful.
Yes, so they do have, it is a very large property, and their facility will be on a small portion of it, but so a lot of the property of the 216 acres will remain open to the conditions that it is today. But for the facility itself, they are proposing, there would be, and it's hard to see, but it's shown on some of the plans, but there is fencing that would be, it's either the fencing where the animals would be enclosed within specifically, but there's also fencing around the facility grounds itself as well. And then all of their animals would stay within kind of the outer perimeter fencing of this compound. And then all of the dogs that are walked around outside of their cottages and their own individual like self-enclosed outdoor areas would be required to be on leashes as well. So they would be not kind of roaming freely around, but they would be in the presence of a staff person that's walking them.
So they are, can we call them, they are kind of supervised?
Right. Yes.
Okay. Thank you. Thank you. I have no further questions.
I have an informational question for me. Not
Please,
necessarily for the
Go ahead.
commission. Is I've lived in a rural area, and dogs bark differently in a rural area. The feral dogs don't even bark. When I lived out on a farm, I've noticed, And yet I know dogs in an urban area bark a whole lot. I've been by kennels in certain areas and they bark a lot. I presume there are other sites like this. I've never seen one before, but I presume this is not the only site. And this, you know, is the barking behavior different at a rural site like this than we would have experienced in an urban site?
We do have other dog kennel facilities in the county, and the one I'm thinking of is up in the North Coast area, Shamrock Ranch, up out of Pacifica. And there may be others. I don't think I have the expertise though to be able to answer that question. Sorry.
It's just informational
I don't know if.
or anecdotal. I'll be
Yeah,
happy
I'll
with.
open the question if anybody else in the audience may have, may know about that a little more. They're welcome to speak. Sorry.
Thank you.
Okay. So would applicant like to add anything more before I open it up for public comments? Okay, thank you. Thank you. So at this time, do we have any hands raised? Okay. Let's bring them on.
At this time, we have one hand raised, David Wilson. David Wilson, please unmute your microphone and begin speaking when you see the timer. Mr. Wilson, you'll have 5 minutes to speak. Mr. Wilson, please unmute.
While he's trying to unmute, I just want to recognize that this is the same speaker that spoke regarding item 3. It sounded from his testimony like he was referring to this item, but when, as you heard, when I asked him, he said it was regarding item 3. So if we continue to have technical difficulties, I think it's fair to proceed with the deliberations because I believe the commissioners heard the comments and concerns. So Mr. Wilson? He is unmuted. So
We do have his written comments.
and we do have his written comments. So my recommendation is we proceed to the next speaker if we have any. We have no additional speakers. So unless Mr. Wilson's able to speak, then I'd recommend you close the public hearing.
Okay. His hand is down, so. And we don't have anybody in the chambers either.
We do not
Okay.
have anyone in chambers.
Okay. So we'll close the public hearing at this time. Commissioners, shall we deliberate, Commissioner Hanson?
I'm in support of this.
I'm in support.
Yeah, so am I. I think
Okay.
we all recognize that there's a huge need for
Need for it.
something like this.
Yeah, it seems to be a well thought out plan, and it's, you know, you spent a lot of time thinking about this. It's obvious going through all the documents, you know, this is now spur of a moment. This is long time consideration, not only for the process, but for the consideration of the animals. I felt it was, and I just applaud that you be able to do this and provide an opportunity for these pets or whatever we want to call it, a place to have where they can live out their lives comfortably with dignity.
Same thing. I commend you for what you're doing. And I think it's a challenging project because I looked at that geological report and you're going to have a lot to deal with. So. Let me see. That's it for me.
Okay. So do I have a motion?
I can do that, yeah. I move that the planning commission adopt the mitigated negative declaration and approve the resource management permit, use permit, kennel cattery permit, and grading permit as per county file number 2021 00316 by making the required findings and adopting the conditions of approval in attachment A.
And I will second that.
Mercedes, roll call, please.
Commissioner Hanson,
Aye.
Commissioner Ketchum,
Aye.
Commissioner Ramirez,
Aye.
Chair Gupta.
Aye.
Thank you. Motion passes.
Congratulations.
Thank you. Congratulations. We move on to our correspondence.
Yes, thank you, Chair
Yeah.
Gupta. The only correspondence we received, the pieces of correspondence that you were provided with this morning. I don't have any additional correspondence to report.
Thank you. Study session.
At this point, we do not have a study session planned for our next meeting, which will be on June 7th. We do have one item of significance, and that is the fourth phase of the rezoning effort in North Fair Oaks to implement the community plan. So I look forward to bringing that to you on June 7th.
Okay, director's report.
Yes, once again, I want to thank Mercedes and Tet for helping out and for the commission's patience since we work out some of these IT challenges. One of the things that Mercedes has been helping with is the production of the minutes, and you may have noticed it has a slightly different format.
I like it.
And one of the suggestions that Mercedes made, which I'm supportive of, is to think about, rather than including all the conditions and findings in the minutes, and rather just make sure the minutes accurately reflect whether or not any changes were made to the staff report during the hearing. I think we moved towards including the findings and conditions to account for the fact that if there were changes made during the commission hearing, that they would be reflected. I think we can do that without having to paste all the findings and conditions by just making it clear if there were changes, what changes were made. If that's acceptable to the commissioners, then we will move in that direction for the next set of minutes.
Could I just
Please.
add, it would be nice to have a letter of decision available, either posted with the meeting materials or, I mean, that's the only use I found is to having him in the minutes, because then you get to see what all the conditions are. But
Right.
and I'm fine with changing that out of the minutes, but
Mhm.
the letter of decision is for the projects is something that I would like to have access to. I mean, not necessarily every project, but still.
Certainly. Well, our practice at the moment is to post the letter of decision in the Excel case, so it should be accessible in the documents of, so if you go to our online permit tracking system and look it up and look at documents, the letter of decision should be there and
Oh,
available
yeah.
for, yes. So, and also in addition, in the instance where we do make changes to this staff report at the commission hearing, be happy to provide the commissioners with copies of the letter of decision to make sure that it accurately reflects the changes that you requested. So in those instances, we could provide it. Great. Thank you very much for your feedback on that.
I have a recommendation, or rather, a request.
Mhm.
I did not receive an email letting us know that the reports were ready.
Oh, that's my
To
fault.
us.
I
So,
apologize.
If you don't mind, just continue and sending that email as soon as those things are ready.
Will do.
Right,
Absolutely. My
thanks.
apologies. So a couple of actions by the Board of Supervisors I wanted to update you on. Yesterday, they considered the appeal of the Sequoia Track subdivision that received your approval, and the board denied the appeal and upheld the Planning Commission's decision. This is for the 23 unit condominium subdivision just south of Woodside Road. Then on the June 13th Board of Supervisors hearing, we'll be briefing them on the comments we received from the Department of Housing and Community Development on our housing element update. So if you're interested in the discussion of that, that will occur on June 13th. We have our upcoming budget hearings in June as well. And the Planning and Building Department budget will be considered on June 27th. And I can highlight any aspects of that at our next meeting prior to that hearing. Final item is with regard to the Moss Beach Chevron project. And I wanted to let the commissioners know that the permit was issued on May 17th. So we anticipate implementation of the improvements required to rectify that violation to be initiated in the very near future. And I'm happy to answer any questions you may have.
Am I squared away with the Form 700?
Oh, my apologies for the difficulties that's caused. Unfortunately, I don't have a good explanation or solution. I do know that our administrative services manager, Ellie Dahlman's been tracking this and corresponding with the representative at the state. I will check in with her right after this meeting to confirm that that has been all squared away. And if there's anything outstanding, we'll follow up with you individually.
I mean, the change was so minor. It was, for 12 years, I've been a commissioner of a commission. That I was the planning commissioner of the planning commission, it seems redundant. And maybe this is why we get Trumpists banging at our door.
Yes, I can't explain, but we're here to help as best we can.
Yeah.
Any other comments, questions? None? So meeting is adjourned.